If you'll identify yourself, you're recognized to speak.
Yes, ma'am. My name is Michael Kaiser. I'm a criminal defense attorney with the Lasseter and Casanelli firm here in Little Rock. As the attorney who handled the Taft versus State case at the trial level through the Court of Appeals, which both houses of this assembly declared as the basis for Arkansas's constitutional carry state, I've been approached by the gun owners of Arkansas to analyze this bill and how it would change things in practice in criminal courts and to give a practitioner's take on this bill in light of that experience. So I've heard from the sponsors that this bill would eliminate the duty to retreat. However, after my review of this bill, I would disagree with that, and I would argue it would perhaps create more situations where Arkansans and other citizens in the state are required to retreat rather than not. My general diagnosis as a practitioner, not anything political, is that if it ain't broke, don't fix it, and if you're going to fix it, don't break it. But that's what this bill will do. And the fact that we have Moms Demand Action here agreeing with a pro-Second Amendment group such as the gun owners of Arkansas that this bill is bad and for drastically different reasons shows that it will not achieve clarity which its sponsors say is going to give us. And so I'd just like to go through each subsection in this new stand your ground bill to point out the issues that I see in terms of practice. And I really feel bad for whichever committee is going to have to put together the model jury instruction here because it is going to be a nightmare. If you looked at the model jury instruction for our use of lawful force in defense of person, it already almost takes a law degree to understand it. I can only imagine what this 4 or 5 page instruction will look like based on this bill. The first issue is in subsection B1, that's on page 3, line 10, and it's the term lawfully present. As an attorney, this is a bad term because what does it mean? I've heard the senator talking at length that if you are trespassing, you can't avail yourself of stand your ground, and then you fall back on the old law. However, that's not true. This new law would remove the phrase incomplete safety. So that's not true, first off. Second off, this lawfully present language does not require the person to be knowingly lawfully present or even recklessly lawfully present. And so if we look at our criminal trespass statute in Arkansas, it requires that recklessness, that knowledge, that purpose. But here, this would detach trespass from any guilty mind requirement, just focusing on the results. So if someone is trespassing without realizing it, for example, if they're in Hot Springs and they're on federal land while carrying a gun, and they don't realize it, they now have a duty to retreat where they would not under existing Arkansas law. So it appears the sponsors of this bill are not achieving their own goal of creating situations or more situations where the use of lethal force is lawful. And there's no definition for this lawfully present term in the bill, and that's a huge problem. Is someone unlawfully present if they're carrying a firearm unlawfully in a place where they haven't been asked to leave yet? Are they trespassing at that point? Can they be lawfully present while engaging in unlawful conduct until they're asked to leave? I don't know because that bill doesn't tell me. And I'm a lawyer with 6 years experience doing these trials. It concerns me what the average Arkansas citizen would come up with. So at the very least, I would implore you all to add some sort of definition or to add some sort of knowing requirement to lawfully present. Moving to subsection B2, this is incredibly superfluous, which, as I understand the purpose of law, it is not to be superfluous. But we already have that requirement in another section of the self-defense law. It's unnecessary. Subsection B3, that's page 3, line 15. It appears to create a new anti-provocation requirement that doesn't exist under current Arkansas self-defense law. So that if I provoke somebody and they react in a way that is overreacting with lethal force, I may not be able to avail myself of Looking at subsection B4, that's line 3, or excuse me, page 3, line 18. Again, it's superfluous because we already have felon in possession law. But this subsection, even arguably, this could be read to empower felons to have firearms as long as it's in their home or in the curtilage. Because this expressly creates an exception that allows them to stand their ground in that way. So it's almost vitiating the felon in possession statute that we already have, which seems a little odd. We already have a law to cover that situation, by the way, and I've had a client charged in that situation, a felon with a firearm who shot someone actively engaged in the sexual assault of a child. And what that defense is the choice of evils. If we had gone through a jury trial in that case, we could have presented to the jury, what was I supposed to do? Allow this to occur or violate this crime? And if the jury accepted that, he would have been acquitted. So we don't need this to cover that extremely rare situation. There's also some concerns with subsection B6. It doesn't allow stand your ground to apply to people engaged in any activity in furtherance of a criminal game, not criminal activity. So if a kid is going and buying a sandwich for someone that's a member of their gang, are they not allowed to stand their ground? Under this law, arguably, no.